which is the fact that there is already on the books in Florida a law stating that marriage is between a man and a woman and there is no same-sex marriage allowed. What will really change as a result of this amendment?
Sure. We need a marriage amendment in Florida for the same reason Massachusetts did. I mean, they have valid marriage law as well until activist judges sought to, instead of being intellectual academic arbiters of what the law is, decided to be social change agents and strike down the law. And that's the problem in this country. There's a movement amongst gay activists and amongst federal judges. This is no secret, folks. I mean, we've passed this amendment in 27 states for this very reason. This wouldn't have happened without Massachusetts and Lawrence versus Texas and the problem of judicial activism. So that's why it's needed and it's important in the state of Florida. I have 30 seconds. There's no legal authority whatsoever that she can quote you to support her argument. The Florida Supreme Court has spoken on this. It does not affect benefits of unmarried partners. The second DCA in Low versus Broward County, I've supplied you with documentation, not propaganda. You have cases in front of you. I've provided excerpts. You can look it up if you're really interested in the academic exercise behind this and not just rhetoric. The courts have been clear that this will not affect unmarried partners or domestic partnerships in Florida.
Because that's not what the Supreme Court said at all. In fact, the Supreme Court said this was a single subject. That was all they were asked to determine, that it was a single subject in order for it to qualify for the ballot. And that single subject was whether or not the benefits of marriage could be denied people. And the language is substantial equivalent. What does that mean? Oftentimes, John will dance around the issue of civil unions or domestic partnership, comprehensive domestic partnership like they had in New Jersey or in California, because those kinds of protections really do create a safety net for people who don't have the ability to marry, as same-sex couples do not have the ability to marry. But it's also a massive safety net for many of our seniors who, once they're widowed, they don't remarry, even though they develop relationships, familial relationships. You know, people like Clarice Pollock and Ed Lesson have been together for decades, and they rely on domestic partnership protections. The vast majority of domestic partnership policies around our state are accessed by heterosexual couples, and so the Supreme Court has not ruled on this. This will be fought in the courts, and the Broward case has nothing to do with this amendment. It had to do with existing Florida law.
Why have that language at all? Why not just stop with the first part of that sentence?
Great question. Let me read to you, quote you from the Florida Supreme Court. The amendment essentially tracks the language of the current statutory provision. The proposed amendment is essentially inserting this statutory provision into the Constitution with language substantially similar to the provision itself. Okay? So it doesn't do anything new. It just protects something that's old and, frankly, very precious to our society. When we argued this case before the Supreme Court, the ACLU said, judges, this is about two topics, not one topic. It's about marriage and it's about collateral benefits. And the court said, no, it's about one topic. It's about marriage. And they struck down, they disagreed with the ACLU, and they cited for us that it deals with marriage and marriage alone and did not infringe upon these collateral benefits. Domestic partnerships grant 4 to 6 benefits: the right to bury your partner, the right to visit your partner in jail or in hospital visitation. It's a very small bundle of benefits. Federal marriage and federal law grants 1,138 rights. You'd have to have an arrangement that was a substantial equivalent of those rights in order for it to be outlawed in the state of Florida.
But again, John, if I can just repeat my question, why put that language in the first place?
Because it makes it crystal clear that you have to have treated as marriage is kind of fuzzy, but even the court has ruled that there's nothing in Florida that's treated as marriage. But to say to have a substantial equal to marriage, then you have to have a full-blown marital arrangement. So it's making it crystal clear that the amendment will not affect the current domestic partnership, which only grants a small bundle of rights.
So what would be a union that would be considered?
You'd have to have a full-blown gay marriage union that would grant all the rights and all the benefits and all the privileges of marriage.
What does substantial equivalent mean? What he wants to outlaw are civil unions, the possibility of civil unions in Florida, the possibility of comprehensive domestic partnership. There's no one single definition of domestic partnership. In California and in New Jersey, domestic partnership has provided all of the same protections that marriage does without the state legal recognition or the federal legal recognition. That would be possible in the state of Florida, but not if this amendment passes. And that's the sleight of hand that's happening here. He likes to talk about the existing smaller domestic partnership benefits that exist around the state, and those will be in trouble if this is allowed to pass. And in fact, in other states, we're seeing where there's an attempt to get private companies who provide domestic partnership to not be allowed to provide those if they get any sort of government money. But the bottom line is this. The substantial equivalent includes civil unions, includes comprehensive statewide domestic partnerships that have in other states. It includes, and because it's so vague, it means whatever the court decides it means in the cases that will inevitably flow as a consequence of this amendment. So it's not just about what we have now, it's about providing protections, allowing people to take care of their loved ones, and this is by trying to sort of stoke anti-gay sentiment, they're hiding what they actually are trying to do. Right now in Florida, this is not a fight about gay marriage. There's actually 3 laws on the books that prohibit gay people from marrying. No matter what you think about that, that's where we are. But what this would do is go much, much further and take away benefits and deny the possibility of benefits that most Floridians think are just basic decency, the way people ought to be able to take care of their loved ones.
Get it.